good, I guess, afternoon, everyone. My name is Lisa Thompson, and I'm so excited to be speaking to you today. This is the first of a six-part business law series that we're doing for Arizona Legal Talks, and I'm super excited about it. We tried to get a bunch of my trusted colleagues to present on various areas of business law. So without further ado, we're going to talk about business entity forms, form selection, and personal liability protection. So, as I said, my name is Lisa Thompson. I've been practicing 30 years. I'm licensed in Arizona, California, and Nevada, and I write books for Thompson West. Um, and I've been doing that since 2004. I update them annually, which keeps me really current on what's going on. And so, you know, I I'm hoping that the series kind of talks about all the topics in the books so that you can get a really good grasp of what's going on in Arizona. I act as in-house counsel to small to medium-sized businesses, and I do all manner of business law from setup to hopefully not dissolution, but if that happens, we can handle that too. All right, so here's my philosophy. There's no one size fits all for businesses. There just isn't. I mean, there are certain things that are basic truths, but I can't say each one of my clients is going to need, the exact same business structure. There's certain things that I think always need to happen, but I want to educate my clients so that they can make an educated decision. So a lot of times I don't care what the decision is, so long as my client has knowledge and they're making an educated decision. So when you see things today, I'm giving you information so you can make a choice about what's right for you. I definitely think that if you can get counsel, talk to tax folks, and getting everything done correctly the first time before it's a crisis, it's going to save you money. Um, I really think that running a business is an incredibly hard job, and people don't even realize I'm a small business owner, and I can tell you I hate all the administrative stuff that I have to do. So, we're going to talk through the series about having a qualified team, and that's going to help you stay educated. It's going to cut out all of the noise that you hear about things and ultimately save you money. All right, so our goals for today is if you are here and you are already an entrepreneur and you've been running your business for a long time, great. And if you're a budding entrepreneur and you're just getting ready to get started or you're somewhere in between, we're going to talk about the types of business entities. We're going to talk about the appropriate terminology to use and the personal liability for your business debt. And and what you know and what you might not know. So even if you've been doing this for a while, hopefully you're going to listen to this and be like, check, 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 5 gold stars for me. Or if there's something that you missed, you're going to be able to catch it now before it's a problem. So as always, this seminar is for educational, informational purposes only. There's no substitute for obtaining legal advice from a qualified business law attorney about your personal circumstances. Just make sure that they work with new businesses or your type of business, or that is a significant portion of their practice. You do not want a one-person firm that can handle your personal injury, your cousin's DUI, write a will, and set up your business. Firms that have a lot of attorneys can do that, but if you're talking about, a 1 or 2 person firm, you need to make sure that they have the skills to do that, and it's not just getting business. I'm not a CPA, and I'm going to say this throughout this seminar. You have to have someone who is a qualified tax professional. There are so many things that I am constantly learning that I'm like, oh man, I didn't know that. I need to make sure that my clients know that. I need to incorporate that in what I do. And this presentation is not an endorsement of me by the host. All right. So here are our definitions from the day for today. ACC is the Arizona Corporation Commission, and it regulates LLCs and corporations. It does not regulate any kind of limited partnerships. That's the Arizona Secretary of State. But I put this in here because If you want to request these materials from me, I'm happy to send them to you in a PDF. Just email me about it. But if you're looking at them and you don't have the benefit of me talking, I wanted you to have the definitions so you could take a quick look. Business, as I'm going to talk about business today, is people or business entities selling goods or services to the public. Businesses may include sole proprietorships, general partnerships, and business entities. A business entity, for our purposes today, is a structure created by filing paperwork with the Arizona Corporation Commission, as I mentioned above, or the Arizona Secretary of State, which is AZSOS. Business entities include LLCs, corporations, LPs, LLPs, and LLLPs. Also, for our purposes today and legally, if you say the term individual, it means a human or another business entity. So it doesn't necessarily mean humans only. So when I say individual, I'm being very specific that that also could be, other business entities, not businesses, business entities. And when I say people, I mean humans, like as in people. All right, so let's talk about types of businesses. Let's start putting these pieces together. So businesses generally, they're all subject to the state law where they operate. So if you are an Arizona business and you do business in Texas, you're probably going to be liable for knowing the laws of Texas, as well as if you're formed here, you're governed by the laws of Arizona because that is where you formed. And so we are going to only be discussing Arizona businesses today or business entities today, unless I say otherwise. And we will discuss whether or not you want to be an Arizona business entity or you want to be a business entity elsewhere at the end of our presentation. Also, I want to make a point that you can switch between different types of entities. So, for example, if you're an LLC and you decide that you need to be a corporation, you definitely can switch your LLC to be a corporation. But you need to talk to a tax professional because it could cause a taxable event. It may cause a taxable event that doesn't mean you pay taxes, or it may cause a taxable event that may make you rethink uh, you know, switching your structure. But you can switch back and forth. You can also move your LLC or your corporation to different states, depending on if they have reciprocal laws with Arizona. So, for example, I moved an LLC from the state of Washington to Arizona because the business owner moved. The business owner didn't want to be subject to all of the different taxes in the counties in the state of Washington, and the business owner was going to be just doing business in Arizona. So he chose to move the LLC with him to Arizona. So I just wanted to mention that. We're not going to get into the ins and outs of that, but you can do that. So if you watch today and go, oh my goodness, I should have done X, Y, or Z. Oh no, I want to change that. You absolutely can, or generally you can. All right, so sole proprietorships. Not a fan of people doing business as sole proprietorships. So the definition of a sole proprietorship is a single person or two spouses providing goods and services to the public for profit. So this is just you are a sole proprietorship if you like to bake bread and you sell that to your friends, family, neighbors, whatever, and you make money off of it. You are a sole proprietorship. If you're married, your spouse is also part of that sole proprietorship. Sole proprietorships may only be people, humans. Business entities are not a sole proprietorship. Um, Sole proprietorships are not a business entity. And I cannot tell you the number of times I have people say, well, I'm a business. Okay, what type of business? Well, using my example, I sell bread. Okay, well, are you an LLC? No. Are you a corporation? No. Are you limited partnership? No. Okay, so you just sell bread? Yeah. Well, you're a sole proprietorship. No, I'm a business. So that's fine, but you're not a business entity. A business entity requires that you do something affirmatively to create the business. My baking bread is just me in my kitchen baking bread, and then I like go next door and say, "Hey, do you want to buy my bread?" I didn't have to do anything to create my business. I didn't have to file paperwork. Um, so that's what a sole proprietorship is. And sole proprietorships may operate under a trade name. So, for example, so I could be Lisa Thompson doing business as, and so doing business as is DBA, Terrific Tacos. Or I could be Lisa Thompson and my spouse, DBA Terrific Tacos. So I could use a fictional name. That's what it's called. Like when I'm using a DBA, I'm using a fictional name. And all business entities, sole proprietorships, partnerships, corporations, LLCs can use a fictitious name. But just because you have a fictitious name and you're a sole proprietor does not mean you are a business entity. And given how easy it is to form LLCs, you can choose the business entity that you want. But sole proprietorships, as you're going to see later, are very detrimental to the people that run them. And again, if I was just selling like one or two loaves of bread, okay. But I think anytime you're doing anything that's sizable, and especially in this country where everyone wants to sue everyone, um, I feel like sometimes you can get sued for breathing. You need to have the protection of being a business entity. So a general partnership is essentially two or more individuals providing goods or services for profit. Now, you can have a general partnership between uh, businesses. It's less likely. I put it in there. Uh, generally, a general partnership is two people. So it's like, you know, um, I make tacos, but now I need to bring in an expert. And my friend Julio is really awesome at making tacos. Or maybe Julio has, a tortilla maker so that he and I joining together, we are going to make incredible tacos. We are going to sell them all over the place, and we are going to do business as Terrific Tacos. We are a business entity, or we're not a business entity, we're a general partnership, just by virtue of the fact that there's two of us, we're not married, and we're providing a service or a good that we're attempting to make a profit under that. You Let's try that again. We are providing tacos and we are hoping to make a profit from the tacos. We are a general partnership, and you know, and we did nothing to create that general partnership. We just said we're going to make some tacos. We can operate under a trade name. In that case, it would be Lisa Thompson and Julio Smith doing business as Terrific Tacos. And whenever you see that, you see the DBA thing and you see that it's two individuals, or it's two people, or it's two spouses, or it's one person, you're going to know that it's a general partnership or a sole proprietorship. And the reason why we allow spouses to be a sole proprietorship is because in Arizona, we considered a married couple to be a community. So we treat that married couple as one. And so that's why you still hear sole proprietorship. In other states that are not community property states, that may not be the case. So again, these are all creatures of the state, right? And so we're in Arizona, it's a community property state. So sole proprietorships include married couples, and two spouses are considered one. All right, LPs, LLPs, and LLLPs. One of my books is LLCs and partnerships, and I have to write a lot about LPs, LLPs, and LLLPs in addition to LLCs. And I have a headache every day I update that book. Anyway, so it's a limited partnership, a limited liability partnership, and also limited liability limited partnerships. And these are two or more individuals providing goods and services to the public for profit. Um, in order to create a limited partnership, um, you must file a certificate with the Arizona Secretary of State to create them. Like you have to, there's no like Julio and I can't get together and just say, you know what, we're going to be a limited partnership. We could do that, but we have to go and file something with the Arizona Secretary of State. We can't just do it, sua sponte, just us hanging out. Like, oh, that sounds cool. Let's put LP after our name. Um, the Secretary of State governs all partnerships, particularly limited partnerships. Arizona Corporation Commission governs all other types of business entities. Limited liability companies are one or more individuals providing goods or services to the public for profit. Limited liability companies are formed by filing articles of organization with the Arizona Corporation Commission. LLCs are owned by members. Managers run day-to-day operations of the LLC. LLCs in Arizona have no stock. They have percent membership interests. So, for example, if I owned an LLC 100% by myself, I would say I own 100% membership interest in the LLC, or I own 100% membership interest, or I own, 50% interest. There are no annual reporting requirements in Arizona for LLCs. Um, Now, I have in all capitals listed the terms that you use for Arizona LLCs. These are the legal terms. You cannot when you are signing legal documents, you need to use these terms, and they aren't sexy. They aren't like, I am CEO or I am CFO. Most certainly, you can be a CEO or a CFO of the LLC, and that's okay. But you really don't want to use the term president because in Arizona, we do not recognize that as any type of manager of the LLC. And to really keep yourself safe, you need to use the term manager when you're signing the lease or you're signing anything on behalf of the company. Now, if you don't want to call yourself, a member, you could call yourself the principal or the founder or the owner. I think the term managers, you could go CFO, COO, CEO. That would be fine. You just do not want to use corporate terms that we use in Arizona for corporations and all over the nation. Um, all right, so corporations, you're going to know that it's a corporation if you see Corp, Inc., Ltd., Incorporated, Limited, Corporation, or Company after the name. A corporation is one or more individuals providing goods or services to the public for a profit. Corporations are created by filing articles of incorporation with the Arizona Secretary of State. So for LLCs, it's articles of organization. For corporations, it's articles of incorporation. Corporations are owned by shareholders, also called stockholders. The shareholders elect a board of directors. The board of directors sets policy and procedure for the corporation, and it elects officers to run the day-to-day operations of the corporation. And the legal terms we use for officers of a corporation are president, vice president, secretary, and treasurer. And that's why you do not want to use those terms when you are, an LLC. So, because we keep these aside for corporations. With LLCs, it has its own. And you want to be really clear when you're signing legal documents to use the legal term for your, um, your office, whatever you're doing. Corporations have stock, also called shares. So if I was an owner of a corporation, I would say Lisa owns 10,000 shares of stock in Thompson Law Group PC. Corporations are required to have annual meetings. And they have other formal requirements. But the board of directors is required to meet annually, and the shareholders are also required to meet annually. So shareholders meet to elect the board of directors meets to elect the officers, and that has to happen annually, and there has to be an annual report filed with the Corporation Commission. Now, I am actually a corporation. I'm a professional corporation, which we're going to talk about in a second. And it's only me. I'm the only one that owns it. And so that's why it's one or more individuals providing goods or services to the public for a profit. Now, that seems really, really, really silly, right? Why would I be a corporation? Is it just me? Do I really need to have a meeting with myself with my 10,000 shares of stock to vote in the board of directors, which is me, and then have the board of directors, me, vote in all the officers and vote me as president, me as vice president, me as secretary, and me as treasurer? Um, I win all of the elections. I'm super popular at Thompson Law Group. Um, the reason for that and the reason why I am a corporation is when I formed back in 2001, it was not possible for me to be taxed as an S corporation unless I was, in fact, a corporation. So now LLCs have the ability to choose the method of taxation, like how they want to be taxed. So you can be an LLC and say, well, it's just me, so I'm going to be an LLC because there's no annual reporting requirements, but I'm going to be taxed under subchapter S of the Internal Revenue Service Code, and I'm going to be treated like an S corporation. So we have a seminar. It's in November. I think it's November 13th, and we are going to talk all about how different entities can be taxed. So that was my little teaser for that. Also, when people come to me and they are in fact a corporation, they will say, "No, I'm an S corporation." Okay. For my purposes and for our purposes legally, you're a corporation is a corporation is a corporation. Whether you are taxed under subchapter S of the Internal Revenue Service Code or subchapter C, you are a corporation. If you're an LLC, you can choose which method. You can choose like to be a disregarded entity, or you could choose to be taxed as a partnership if you have more than one person. You can also choose to be taxed as an S corp or a C corp. But for our purposes and for the purposes of liability, it doesn't matter how you're taxed. That's simply a conversation you're having with your qualified tax professional as well as your CPA. All right, so professional corporations, which are designated by PC, and professional limited liability companies, which are designated as either PLLC or PLCs, are simply an organization for a business that is required to be licensed by the state. Right. So in order for me to be a law firm, I have to be a licensed attorney in the state of Arizona. And attorneys, until recently, could not have any non-professionals own any of their business. So like if I wanted to bring on a partner, I that needed to be a licensed attorney in the state of Arizona. Now that's been relaxed a little bit, and so you can get permission to bring in like a CPA or something like that. It's pretty rare, but professional corporations are just that. So you'll see PC for doctors, you'll see it for CPAs. That's what that designation means. Professional LLCs, same thing. By the way, on a fun note, professional LLCs do not exist in the state of California. You may not be a professional LLC in California. So if you are a PLLC and you're looking to do business in California, you need to have a conversation with me or someone else, and also your tax person. But anyway, so that's all that being a professional corporation or a professional LLC is. It's like doctors, lawyers, real estate brokers, folks that are required to be licensed in order to do what they what they do as their profession. So for our purposes, I'm not going to say corporations and professional corporations. I'm just going to say corporations because they're exactly the same, and the same for LLCs. All right, so internal governing documents for business entities and default law for those entities. So, with limited partnerships, all types of limited partnerships, partners may create a partnership agreement to determine how the partnership will be operated. It is not required by law to create a partnership agreement, and partnership agreements are not public if, in fact, there is one. LLCs. Members, the owners, remember that, may create an operating agreement to determine how the LLC will be operated. It's again not required by law, and operating agreements are not public. If you are in business, even if you are a single member LLC and you do not have an operating agreement, or if you're in a partnership and you do not have a partnership agreement, I, that is like Russian roulette because there are so many things that can go wrong with that. And people laugh when I say that about single member LLCs. There is, when you're being protected from personal liability, there's two different ways to be protected. There's the piercing the corporate veil, which is up here, and then there's also your personal ownership interest in your company. And if you don't have an operating agreement, um, you can have issues with having a creditor come in and take your ownership in your company. It's way too long of a conversation here for today, but I am going to say make sure that you've protected yourself and your business and your family in all ways possible. And if you talk to an attorney and you say, I need to be sure that I protected from reverse piercing the corporate veil, and they don't know what you're talking about, you need to find someone else. All right, corporations. The board of directors must create bylaws to determine how the corporation will be operated. Bylaws are required, although they're not public unless the corporation is publicly traded. But you must have bylaws. So I will tell you that Thompson Law Group has bylaws. Thompson Law Group also has annual meeting minutes. All of our meetings happen on Cinco de Mayo, so I can remember to do my meeting minutes. And basically, it's me searching and replacing, like, search 2024, replace 2025, sign that Lisa won all the elections and she's all of the officers. Um, so you do need to keep those formalities. And another thing is, you really want to make sure you use the proper terminology. You want people to know that you understand your business. And and this is for now and in the future. Because when I'm doing due diligence on a buy-sell agreement where either my client's buying a business or is selling their business, and I'm looking into the other side and their records are a mess, or they're calling themselves the president of an LLC and they were formed in Arizona, and I know that, there's no such thing as a president of an LLC in Arizona. Um, I I question what else they're not doing correctly, right? If you can't get the basics right, you either don't care enough to know about the basics, and if that's true for your business structure, then what else is not up to speed? So I just think that it's really important if you are going to, have a business, make sure that you use the proper terminology, um, because that's just what it is. All right. Um, Default law. So if you don't have a written document, so my litigator friends, the people that file lawsuits, are going to be really sad for me saying everyone should have a partnership agreement, everyone should have an operating agreement. It should be in writing. Um, Preferably not on a cocktail napkin. Like, get it in writing, to protect yourself and also protect your relationship with, whoever you're in business with. Because if you get into a fight, you need to know, how does one person get out? What if someone dies? How do you distribute that? What if someone is incapacitated for a period of time? What happens then? How do you how are you going to manage these things? What if I no longer want to be part of the business? How are we going to value it? How do I get bought out? Well, if you don't have it in writing, I guarantee you at the time I want to leave the business, I'm going to think that it's super valuable because I'm getting bought out. And whoever I'm in business with is going to say, oh, no, it's not very valuable at all because they're going to be the ones buying me out. You want to come up with a formula and a mechanism for folks to be bought out. You want to come up with a formula and a mechanism for heirs to be compensated if, God forbid, someone dies. You want to come up with these things at the beginning when everything is all hearts and roses, because when it's not, that's when my litigator friends make their money. They further make their money when there's nothing in writing and nobody agrees and there's no law to govern it. That's when you're spending hundreds of thousands of dollars in a lawsuit with no guaranteed outcome. So put your deal in writing. That's going to be the best free legal advice you ever give or that you ever receive. Put it in writing. Put it in writing, sign it. I have clients that I'll do an operating agreement for them. It'll say everything that they want it to say, and they never sign it. It's no good if you don't sign it. If you don't know if you have an operating agreement or a partnership agreement right now, or bylaws, which bylaws are required, you're not in compliance with state law if you do not have bylaws and you're a corporation. Contact someone, get them in place. If make sure they're signed, go back to your office, look in your drawer right now. I give you permission, find them, scan them to your file so you have them saved electronically. Make sure everyone knows about them, update them if they're old. Just make sure that you really protect yourself. Um, you also want to do this because if you don't have anything, you're going to be governed by the law. And in some instances, the law is quiet, and in some instances, it's not so quiet. So, like, for example, the law imposes a duty not to compete and not to have a conflict of interest with your business. Now, a lot of my business clients are real estate developers, or they buy and sell properties, they flip properties, that kind of stuff. Well, just because they're in business with one guy doesn't mean they don't want to go into business with, someone else. And because that's their business, they're constantly doing this. So they don't want to be prohibited because they're in business, on this one deal from doing another deal. So they specifically say, you know, you can go, all of the owners of this company may continue to do their other work and continue to develop other real estate property. But if they don't do that and someone got grouchy and decided to fight with them, the law says that you can't compete with your business. So that would be a big problem. And so you definitely need to put something in writing so that you can contravene what the law says, because that is not what you want. Another example is, if you don't have an operating agreement, that states how votes are going to happen, or how profits and losses are going to be split between owners, then they're going to be split, and the voting rights are going to be what the default statutes of Arizona law say. And so for a while, Arizona voting default statutes for LLCs said that every single member got one vote. Didn't matter what the percent interest was. So imagine that. You haven't written your operating agreement that says all owners vote their percent interest in the company, right? So you have a 4% owner and you have a 96% owner, and there's nothing in writing saying that they vote their membership interest. And you have to use the law for that. And the law says it's one vote per person. Well, you have someone with 4% having as much power as someone with 96% ownership in the business. So if again, all of this is educated decision, right? If that's okay with you, if the default provisions are okay and you know what they are, fantastic. Run with that. But if you don't even know what they are and you don't have anything in writing, then you're really, again, Russian roulette. All right. Personal liability for business owners. If you are a sole proprietorship or a general partnership, you are 100% responsible for all business debt. Um, if there's a problem with your business, if it fails, the only escape would be personal bankruptcy, right? There's no separation between you and your spouse and the business. Even if your spouse is like, Lisa, I do not want you to make another taco. Please don't make tacos anymore or bread, nothing. Don't sell anything. We're done. My spouse is still going to be responsible for the business debt if my business fails. And also, if I'm in my general partnership with my friend Julio, his wife or his spouse is going to also be responsible for um, our business debt, even if he or she is like, no, please stop making tacos with Lisa. Don't make bread with Lisa. Don't do it. Ah, you know, they're still going to be responsible because, again, community property state, there's no protections for folks that are sole proprietorships or general partnerships. None, zero, niet, nothing. And so I love when people say to me, like, well, I'm a sole proprietorship. I've been sole proprietor for, 40 years, 20 years, whatever the time period is. And they're like, it's worked for me. I've never had a problem. And you know what? That is fantastic, awesome. That's great. Um, and if that's what you want to do and you understand what the risks are, go for it. Be free. I just think that when it goes bad, it goes really bad. And if it hasn't gone bad, that's awesome. Fix it. Like create a business entity. It doesn't you don't have to be a corporation like I have to be because of when I formed. Now it's so easy to get something set up right and then just have it run itself once you know what you need to put into the business. So anyway, so it's really about the separation between business owner, business. Treat business owner stuff separate. Business stuff is business stuff. Like when you form a business entity, it's sort of like having an adult child. It has its own social security number, which we call an employer identification number. It has its own, you can it can file its own bankruptcy if it needs to. It can dissolve. It can be terminated. It makes its own contracts. It does all things separate and apart from you. And so it's really important that you keep that everything separate. And that's why there's no personal liability protection. There's no limited personal liability for business owners that are sole proprietorships or general partnerships. All right. Um, so in limited partnerships, LPs, LLPs, and LLLPs, there's always one general partner, and then there's one or more limited partners. General partners are 100% responsible for partnership debt. Limited partners have limited personal liability for partnership debt. Um, in limited partnerships, the partners aren't responsible for each other's um, malpractice uh because LPs, LLPs, and LLPs are typically used for like CPA firms and again attorneys and doctors. Sometimes they're used for land deals, but one of the reasons why they were quite attractive was because the partners were not responsible for each other. And as an attorney, or as a doctor, if we malpractice, it's on us personally. And so if it's an LP, then you're not responsible for your other partner's mistakes. So that's why it was considered very favorable. I write an entire book on this and I do very little work in this area. They're not super popular. All right. So, owners of LLCs and corporations. So as of now, I view the personal liability protection for owners of LLCs and corporations to be exactly the same. Like I don't see a benefit from a personal liability standpoint, um, between being an LLC or a corporation. I don't think that there's more or less. The one thing with LLCs is that they've only been in existence um, just in the lifetime of my career, and they've evolved over time. So there's not quite as much um, case law about them, interpreting them, and I would have had a different opinion 20 years ago than I do now. But everyone just treats them, if the business owners are treating them as separate and apart, then everyone treats LLCs and corporations kind of interchangeably as far as personal liability goes. But by law, there is a law, and it says in black and white that members and shareholders are not responsible for business debt by law. Managers, which are the officers, for lack of a better term, the managers of the LLCs are not responsible for business debt, and neither the officers or the directors are responsible for business debt of corporations. And again, these are statutes. Like, this is me interpreting something. There is a statute that says members and managers of an LLC are not responsible for business debt by virtue of being a member or a manager in an LLC, period. End of discussion. Now, you can be responsible for business debt if you sign a personal guarantee. So, a personal guarantee is just when you're agreeing to pay the debt when the business cannot or will not pay its debts. And so, whoever signs that personal guarantee is responsible for payment of the business debt. You will have to, as a business owner, sign personal guarantees. It's pretty rare that you don't have to sign a personal guarantee. Um, it's rare. And if you don't know if you've signed a personal guarantee, probably you did sign a personal guarantee. Because the people that did not sign personal guarantees, they know it. Because they negotiated for it, or they did something so that they wouldn't have to sign a personal guarantee. So you just want to be aware that if your business fails, you still personally are going to be responsible for that debt. Or if you're in business with someone else that's not your spouse, and he or she wants you to sign a personal guarantee, if the business fails or will not pay a debt, then they're coming after you personally. Now, again, you're going to have to sign personal guarantees. Like, I don't know a small business owner or a new business owner that gets away without at least signing one personal guarantee. You just need to be aware of what that means. Like, when I sign this personal guarantee, if something goes wrong, I'm going to be personally responsible for it. And that may also be something that you want to include in either your bylaws or your operating agreement, or your partnership agreement that says, okay, if, one of the owners has to sign a personal guarantee, you know, then we want the other ones are supposed to compensate that person if there's a problem. Like, we want to spread it around everyone so there's not one owner that's responsible if the business has some trouble. Business credit cards. There is no requirement in the state of Arizona for an authorized signer to sign a business card agreement. If your name is on a business credit card as an authorized user, then you are personally responsible for that. And most people don't know that. So, if you're watching this and you're thinking about going into business for yourself, and you actually have a credit card for, your employer, um, technically you could be held personally responsible if your employer doesn't pay the credit card. So, using the credit card um, indicates acceptance of terms of use. So, making the argument like, I never signed a personal guarantee for credit cards in the state of Arizona does not work. So, if you are on anybody's credit card, and your name's on it and you use it, you are responsible for that. Again, educated decisions. Like, you're probably going to need to have a business credit card. It's just like you signed a personal guarantee, so long as you understand that. Um, when I was filing bankruptcies, I would have spouses come in and one of the spouses would say like, it's all his debt. He went to Home Depot. It's not mine. Okay, well, do you have the same credit card? Yeah. Did you use it? Yeah. Well, then it's your debt too. I don't care if he has a Home Depot problem or not. Like if you're authorized and the card gets used, be responsible for it. All right. So to keep your limited liability, you need to make sure that you treat yourself differently than your company. So it really needs to be um, separate and apart from you. So I liken it to wearing a different hat. And it's hard when it's just you because I made the joke earlier. Well, it's not a joke, it's truth. I am the shareholder of my corporation. I am also the board of directors and I'm also all of the officers. And I'm an employee. I'm a W-2 employee for my business, which is why I ended up being a corporation because I wanted to be taxed under subchapter S of the Internal Revenue Service Code. So I am an owner, an employee, a director, I'm everything. And so, I hear this from my clients and they're like, well, why can't I pay my mortgage out of my business account? It's like all my money. You can't. If you do that stuff, then if you ever get into trouble, if your creditors ever come after you, they're going to look at it and they're going to say, no, you know, that person used the business entity as a plaything. Like they there's like la la la, I paid my mortgage out of it, I bought groceries, I did all this stuff that wasn't what the business entity was intended to do. So I think a lot of times it helps to ask yourself, if I own stock in McDonald's or I had a membership percentage interest in McDonald's, could I pay my mortgage out of, I changed the slide and I forgot to take IBM out of there. Sorry, guys. Um, Out of McDonald's bank account. Well, the answer would be no. McDonald's or IBM, if you're a shareholder, is not going to allow you to take um, pay your mortgage out of its bank account because it's not your money. If you're acting as an employee and you're an employee of McDonald's, can you just be like, hey, McDonald's, can I pay my mortgage out of your bank account? Is that cool? They're gonna be like, no. What happens is you get paid your W-2 wages and then you pay your mortgage, or you get paid as a 1099 and then you pay your mortgage. If you're an owner, you get paid your dividend and then you pay your mortgage. You got to keep it separated. All right, so what business structure should you choose? Again, it's not one size fits all. Like there's not, I think generally if you're in Arizona, it's probably going to be an LLC, but not always. And so you want to look at where your business is going to operate. What is your personal liability going to be? What's the availability of default laws? Like, what if you miss something in your operating agreement or you don't have one or it doesn't get signed? Like what's up with that? Um, can you, or, depending on the structure that you have, um, can you effectuate your business purpose? Like if you want to be a holding company, certain business entities cannot be owned by another, like a subchapter S corporation can't own any type of business entity, right? So you need to think about, how the taxation is going to work and is the business purpose going to be fulfilled by forming the certain type of business entity you're going to form. Um, the number of owners. I My general rule is if I have a bunch of owners, and it doesn't matter if they're related or not. And even if they are related, I think this is even truer what I'm going to say. Um, I think that they need a corporate structure. Like they need the structure of you are a shareholder. The shareholders vote in the board of directors. The board of directors votes in the officers, and that changes annually. And we have a written document called bylaws, and that's how we do it. Um, so if you need a very formal structure and you need to make sure that things are super clear, you might want to look at being a corporation. It's not, I mean, I do it. It's not that big of a deal, but it might be helpful if you have a lot of owners, or if you think that you're going to do an initial public offering, if you're going to go public, if your goal is in 15 years, you're taking that company public, you might want to start out as a corporation. Um, and then also, the tax ramifications, like can your business entity be owned by the owners you propose? And that kind of goes like, can you have an S corp own it? Can you, if it's a certain type of business, um, you know, can can that work with what you want to do? And also, will you be able to utilize the most favorable method of taxation? So all of these are considerations. There's no definitive thing. But you need to be considering all of these and talking to your advisors about them. All right, I get this a lot. Um, so if you are forming a business in another state, you need to be able to answer the reason why definitively, not just thinking it, like you need to know why it's good for you. So I get people calling me all the time, like, hey, I want to form a Nevada LLC. All right, that's cool. I'm licensed in Nevada. We can do that. Why do you want to be a Nevada LLC? Because you live in Tucson. Oh, well, Nevada doesn't have any personal income tax. Okay, well, you live in Arizona, so you're going to pay personal income tax. Like your LLC isn't going to pay any tax because it doesn't pay tax unless you choose to be taxed as a C corp. But like so being in Nevada, like are you doing business in Nevada? No, we just don't want our LLC to pay tax and we don't want to pay tax. Well, then you need to move to Nevada and operate in Nevada. So I think there's a lot of misinformation out there, like, oh, it's so much better. You should be in Wyoming. Okay, tell me why. And I'm not saying don't do it. Do it for a reason that you understand that makes sense, because I guarantee you it's more expensive than just having a location here in Arizona. And I'm not saying Arizona is the best place to always, this is a presentation in Arizona, so I'm assuming we got all Arizona business owners. It will be more expensive if you form in another state and you operate in Arizona. Period. End of discussion. How much depends. The only reasons why I have seen that it would make sense to be in another state, is if you wanted to have some anonymity. If you're super big, Delaware might give you more favorable law. But when I ask you the question, you're like, I'm in Delaware. I want to know what the favorable law is. If not, you're not making an educated decision. I had a client who decided it would be super cool to go and got, one of these third party filers to file an LLC for him in Delaware. And I said, why are you in Delaware? He's like, because everybody's in Delaware. Like, okay, well, now you need to register in Arizona because of what you're doing. And so, that's an additional fee. And you have to have a statutory agent here, la, 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 right? He also didn't get any information about what happens in Delaware. Well, Delaware, one, has an annual reporting requirement, and two, if you don't do your filings correctly, you can get a very large tax bill. So he got a bill for $80,000 from Delaware. Now, um, it was just because something was filed wrong and we fixed it, and it was not a big deal. But um he shouldn't be in Delaware in the first place. So he had a heart attack about something that was done incorrectly. But he shouldn't have even been there in the first place. And he wasn't making an education decision about it. Like this isn't one of those like in high school you want to be one of the cool kids. No. File your entity where you're going to work, where your business operates, unless you have an identifiable good reason not to, and you understand the risks and the benefits of that. All right. So you may even if you're formed in Arizona, or alternatively, if you're from another state and you're working in Arizona, you may have to register and be, we call it a foreign, insert LLC here or LP here, foreign blah, doing business in Arizona. And that's just a ministerial act that generally is done in other states. They do not have a corporation commission. It's all done with the Secretary of State. Here, as I said, Secretary of State of Arizona is partnerships, and LLCs and corporations are with the Corporation Commission. Um, you want to, I kind of mention it because it dovetails with what I was saying before. It is critical, critical to get tax information when you're going into other states and you're forming into other states. And also, qualified business law attorney in that state. Um, Also, you need to know at what's the threshold or the nexus when you will have to pay taxes in that state, even if you're not located there. Like if you're selling product in California, you could be required to pay taxes there, even though you don't have a brick and mortar building. I've seen that happen. Um, so it's just really important if you know that you're not doing just one-offs in different states to know what you're getting yourself into. And if you need to register, as a foreign LLC or a foreign corporation doing business within that state, because you don't want to get in trouble. All right, third-party companies that form business entities. I'm a big fan of DIY. I watch YouTube videos a lot, but there are certain things that you really, again, educated decision. Forming an LLC is easy. There's no magic. I can do it. I don't feel the need to do it. What's critical is knowing what's in it and how to operate it. Um, if you go to a third party filer, they'll do it. I saw one where, they'll do it for $30 or something ridiculous like that. Okay, cool. But it's just like you did it yourself. If you're going to get a third party filer, why don't you just do it yourself? They don't have any insurance. They're not going to give you any legal advice. They're going to give you a bunch of documents which you won't understand unless, you've been educated about it. And they're going to sign themselves up to be your statutory agent, which is a recurring fee every year. Um, One of the companies that's fairly popular right now, um, you know, forms your LLC or whatever it is for, $30 and then charges you 250 for statutory agent services every year. And in order to cancel, you have to let them know 6 months ahead of time so that, because you signed a contract long ago in a galaxy far away when you thought you were getting your LLC for $30. Again, educated decision. Understand what you're getting and understand if someone else forms your LLC or if you do it yourself, there's no insurance to look back on. If it's done incorrectly, or you haven't, got the guts of it or you're not running it appropriately, that it will be on you. So a third party filer is as though you did it yourself. All right. This is my last little pitch. Really have a professional team. If you're getting started right now, get a qualified business law attorney, qualified tax professional. I even think that you need a qualified insurance person. I also think that you should talk to a qualified intellectual property law attorney. Um, you want to have a team before you need a team. uh, they're going to let you know the things that are changing. They're going to let you know, um, what it is that you need to be doing and keep you abreast of it because that's not what you do. And it's hard enough for me to stay up to speed on business law, you know, much less also staying abreast of all these other things that you do. And you really need to be running your business. So I don't know if the attorney's the chicken or the egg or the qualified tax professional, but you definitely need both. And just because you get advice from a business law attorney, you definitely want to check with the tax professional as well. All right, because it's all interconnected. Every single thing that you do with your business has a tax ramification and a legal ramification, always. So if your CPA formed your LLC, it's just like having a third party filer. You can let me do your taxes, which would be ridiculous because I'm not a qualified tax professional. CPAs and tax professionals should not be forming LLCs and giving that kind of advice. You need both. Um, and you also want to be thinking ahead and you want to be talking to your team about like, this is where I want to go. Like I want to take my company public. I want to expand into Nebraska. What are the steps that I need to take now? So I'm ready for that expansion. I'm ready for that growth. Or what can I do to be protected if that growth doesn't happen? Or if I have to dissolve? Like how can I protect me and my family? And is there anything else that I need to do? And that's it. Um, Please look at our website. I have a blog. I try to keep it, well, I do keep it up to date with things that business owners care about, as well as tax information for businesses. I have business frequently asked questions, and you can subscribe to our updates.